Ladies and gentlemen, hello, y'all. All right, everybody's going to have to pay me $5 if you're still talking after I finish this statement. Anyone? Rats. That's a good way to clear the room. Anyway, welcome to your Juvenile Justice Committee meeting. We're going to go ahead and get started in just a minute. I just wanted to kind of briefly lay out. We're going to hear House Bill 79 first, then we're going to move on to House Bill 472. And the chair will now recognize Representative Gilliard to present the bill.
Thank you, Madam Chair, and to committee members. We thank you for this opportunity to present to you House Bill 79, LC 480012. About 2 years ago, I had the privilege of meeting a gentleman named Jared McArthur in our district, and every year he came to talk about the issues of the blind, every year, like clockwork, and he gave us the information of some pertinent issues. And we made a promissory to talk about the issues that affected the blind, but this one is very pertinent to Georgia. I believe that this is an opportunity for us to assist the parents. There are over 202,000 blind citizens in Georgia. And so the parents that are legally blind or wanting to parent their children or foster children or to be that custodian parent, some of them were stripped of opportunities and had their children actually taken away. This bill is a proposed bill to protect those parents and give them the rights to be parents. There are trainings that happen when they are in their stages of carrying the child, and there are preparations when they're going to adopt. We have so many testimonies of viable families that have succeeded. I have a listing of several people that have sent me letters, but I've talked to so many. And so we just asked for consideration for over the 202,000 blind citizens to give them the right to parent. And today I do have with me the Vice President of the National Federation of the Blind for the state of Georgia. Briefly, Madam Chair and committee members, Mr. Tootle is here with us just to say a word.
Sure. Welcome to Juvenile Justice, sir. If you wouldn't mind, introduce yourself to the committee.
My name is Galen Tootle, and as Representative Gilliard said, I am the Vice President of the National Federation of the Blind of Georgia, which is a national organization with affiliates in every state of the Union, as well as Puerto Rico, Germany, and other countries in Europe. We are a national organization with a focus on, this year, parental rights for blind parents.
Thank you, sir. Members of the committee, do you have any questions for our guest? Seeing none, thank you, sir. I appreciate your presentation to the committee. Representative Gilliard, if you wouldn't mind, just kind of briefly walk us through the bill.
This is a bill, and of course last year was House Bill 891, and the session kind of concluded us. The DHS actually usually takes care of a lot of our matters of children, family, Department of Family and Children Services. It basically gives them the right to be foster parents, to walk you through a child placing agency in matters of child custody, guardianship, foster care, in visitation, placement, and adoption. The definitions apply to just like a general parent, just not having the physical sight. Blind individuals, the characteristics you will see if you go down to 11, blind individuals, and 13 you'll see face an unfair societal bias, but they're able to be viable citizens. We also have in here what is the characteristics or what is the legalization of what a blind citizen is. In 30 you will see having a vision of 20/200 or less, etc., corrected eyes, but it gives you the description. DHS would be the agency with policy, regulating, and dealing with the training or the awarding of any rights. So, Madam Chair, that's basically what the bill speaks to.
I appreciate your presentation, Representative. Members of the committee, do you have any questions? Okay. Representative Oliver.
Representative Gallagher, I appreciate you bringing this bill. I've represented handicapped both blind and deaf parents in disputes for defects, and I think this bill might be really helpful to give defects and the families some extra opportunities to be heard in the right way.
Thank you. Thank you so much, Representative.
Thank you, Representative. Any other questions from the committee? Seeing none, what is the pleasure of the committee? Multiple motions do pass. Is there a second? There's multiple seconds. All those in favor, please signify by saying aye.
Aye.
Any opposed? Thank you, Representative Gilliard. Move on to rules.
Thank you, Madam Chair and Committee.
Thank y'all. Next up is we're going to be hearing from Representative Reeves on House Bill 472. We're working from LC 480094S. Joining Representative Reeves is going to be Division Director Rawlings, Legislative Liaison Fielding, and
I think Walter's just going to.
I think Walter's going to be lazy and just sit there.
We know where we are if we need you. So.
We know where we can find Mr. Jones. So anyway, y'all just I don't kind of lean, whatever.
Here, y'all take care.
All right. Representative Reeves, if you just want to kind of briefly walk us through the bill and the changes. Well, never mind. I was going to kind of give the committee a succinct overview of Families First, and then I decided, well, we don't have 45 minutes, so I'm just going to move on to the bill. So
I'm gonna let Director Rawlings do that.
Okay.
And there's a handout
Sure.
that's being handed out right now that is a section-by-section summary of what each section of the bill does. But Director Rawlings, if you want to talk about what led us to get here and what this does for the committee, that'd be great.
Okay, just for the ladies and gentlemen of the committee, I will just kind of, if you're unaware, the federal government did pass Families First, which just places a very large emphasis on familial care, kinship care. I know former Minority Leader Abrams really did a lot on kinship care. I think we actually passed some bills that to facilitate that. So, but the Families First from the federal guidelines that we've been given, our state obviously has to come in line with that, given how dependent we are on federal dollars for our child welfare. So, with that, I will turn it over to Division Director Rawlings.
Thank you, Madam Chair. This bill, we're very grateful for Representative Reeves for carrying. As you mentioned, we do have the Family First Prevention Services Act that is coming into operation in 2020, September 2020. This is part of our efforts, I believe, to lay a good groundwork for that. Right now, in some jurisdictions, we give judges a stark choice. Either the child needs protection, so please put the child in foster care, or leave the child simply under the agency's authority. This is an effort to give our judges more authority to work with the agency to keep children out of foster care. Specifically, it gives judges the specific authority and also requires them to consider whether, when the agency believes a child cannot be left safely in the home without some protection, whether the judge can enter an ex parte order to either require someone to leave the home, to require the family to leave the child with a relative or fictive kin, or to take other protective order measures on an ex parte basis until we can get the case into court, which is about within 5 days. We have noticed in the past that in many situations, when our agency asks for a child to be removed, which of course is a judicial decision and should be made with a lot of discussion and a lot of thought, that too often we see children who come into care and then at the preliminary protective hearing within 3 days they actually are returned home. This gives us the opportunity to further advance the purposes of the Family First Prevention Services Act, because we will be able to keep those children out of state custody. We will be able to use federal 4E funds to support those children as they remain out of custody, but we will also be bringing the power and authority of the court to help us back up our efforts to keep children close to their communities, with relatives, with fictive kin, etc. I believe that's the overview of the bill. I'll be happy to walk through the sections if you'd like, Representative Reeves. So we're looking, of course, at LC 480094S. The first section, lines, appears to be now lines 20 through 25, I believe, defines that fictive kin, really kind of gives a more specific definition, that this is a person who, if the judge exercises these alternatives, they can place the child with a person who may not be related, but who already has that substantial and positive relationship with the child and has already expressed a willingness to care for the child. The next section, of course, lines 26 through 31, actually defines what a temporary alternative to foster care is. So, of course, it is an effort by the court to reduce the trauma of removal, to allow the child to be cared for by people with whom they already have a bond or attachment, and but of course, especially to ensure the safety of the child pending further action by the court. The next section, section 2, it looks like lines 38 through 47, emphasize that this is specifically a judicial act. We have had in the past Scott versus Brown, which is a Georgia Supreme Court case from a while back. We've had in some areas where DJJ intake officers were making these removal decisions, and we want to make sure that that's done by the court or by an independent court officer who has undergone training to make sure that they know how to do this balancing act, because this is a judicial decision. In section 3 of the bill, lines 78 through 85. Let's see, I've got to just coordinate here. Pardon me, the lines got a little bit messed up on we redid the LC. This is, of course, emphasizes that that we are required under federal law to make these reasonable efforts to prevent removal, and this emphasizes that is part of that work. Section 4, there's a new section 1511-133.1, lines 88 and following. It's a very long section. So this kind of tells us how we do it. It gives the court the opportunity to, before removing, to do an ex parte order. And that ex parte order can be, if you go down to line 97, can be, of course, among other things, placing the child with a relative or fictive kin. We certainly want to make sure those placements are safe. And so in lines 102 and following, we're going to ask that the court at least require DFACS or the court staff to walk through the person's residence, to do an in-state criminal check, to search the Georgia Sex Offender Registry, to search any kind of Department of Community Supervision or Department of Corrections data. And Madam Chair, this is a point at which I believe you asked the author to add a line, which I will suggest if it's an appropriate time.
Well, we will, once there is a motion to pass,
Okay,
we'll certainly amend that, but I will, for the information to the members, I will be adding hopefully there will be an amendment to add the child abuse registry to what gets checked.
Certainly. This assessment must be done no later than 72 hours from the time the order for the temporary placement is entered. Lines 117 and follows notes that you have to come back before the court within 5 days, and lines 121 subsection E and following indicate that even if, for example, the preliminary protective hearing is continued, or you have a hearing and it's not finally decided, that you may continue these temporary alternatives. If you move on to section 5, let's see, pull my list up here again, pardon me. Lines 135 through 139, and just emphasize that temporary alternatives may be used to prevent child abuse or neglect prior to the adjudicatory hearing. 146 also just emphasizes that under federal law, if the feds were to consider our temporary ex parte order to be a removal, which does trigger some federal requirements, that we want to make sure the judge makes this order based upon a finding that continuation in the current situation would be contrary to the child's welfare, and that to the extent this is considered any kind of removal, it's in the child's best interest. Section 6, line 156 through 159 indicate to us that, like a lot of other more pressing cases, this dependency petition based on such an order as this needs to be heard within 30 days. The other issues, I guess Section 7, we also want to make sure that we are considering, in the case of juvenile delinquency or CHIN situations, when a child, when the court has before the child and may be considering removing that child and placing that child in DFACS custody, lines 173 through 175 state that before placing the child in the custody of DFACS, the court should consider whether the child might be rather instead placed with a relative or a fictive kin. Section 8, lines 189 through 192 have a similar effect. The remainder is that it takes effect upon the governor's approval, and I believe that's a fairly thorough overview, but I'm certainly happy to answer any questions.
Thank you, Director. I do appreciate that. Members of the committee, do you have any questions? Oh, come on. Y'all letting me down. Nobody has any questions. See, there we go. Representative Thomas.
So thank you so much for this measure. I just have a couple questions. My first question is, for me, I always get a little, tense when you think about putting a child, in care of someone that might be a friend or close to the person the reason why the child is left already. So the question with that being said, what kind of measures do we have that we will be putting in place to make sure that if this is a friend, because that could be a fictive kin, could be a best friend of the parent, and that parent could be on drugs or any other additional things to a reason why the child was taken out for neglect or whatever. What measures do we have to make sure that this child is still not going to be around the parent?
So, Representative Thomas, what we can do in that is part of the protective order.
Mm-hmm.
The court so of course, let's assume for a moment that it is mother's best friend.
Mm-hmm.
And yes, I would agree with you that sometimes some of the parents we work with, their friends may have some questionable issues as well. So, of course, the first thing we'll do is require that the person's home be checked out, that a criminal background check is done, etc. The court can also impose other temporary protective order measures, such as the child shall not be around the mother. The caseworker shall go out and check on the child. And of course, remember also that within 5 days of this placement, we'll have everyone in court, including the child's attorney, the parent's attorney, the guardian ad litem, and the judge, and our agency, to make sure that we have done what is right by this child. So rather than simply take that dramatic step of removing the child, we're going to balance the trauma of removal and against the need to protect that child's safety.
Okay, I have one more question. So I don't know. I mean, I'm just thinking that for an example, if a child went in, and I'm just going to use myself for example, when I went into foster care, the first home that I went into was someone that I knew. They were never a foster parent before. They had never, it was my friend's, one of my friends from school's mom, mm-hmm. and I was able to get into her home. I mean, they did extensive background check. They went and searched the home, and we were able to get into the house in one day. So tell me the difference between that and fictive kin, because I mean, I know right now if that was the situation, a child should already be able to get into that home.
Absolutely. And so what we generally find happens is, too often what happens is the child, well, let me give you an example. In some counties, we will have our staff who feel comfortable, for example, in placing the child temporarily with a neighbor while they go to court. And some judges don't feel that comfortable with it. Some county agencies don't. There may be some questions. So what we can do here is go ahead, and if we have a person who's a fictive kin, of course they've already got to have a bond with the child or a relative, and we can go ahead and place that child very temporarily, it is very possible that that person can then become, if necessary, the relative or fictive kin caregiver for the child, even if we later bring the child into custody. Is that what I think the key is? This is all about placement stability. So we do want, if we're able to avoid that quick removal in which we say, better safe than sorry, let's place the child in a third-party foster care home, only to return the child to a relative shortly thereafter. This gives us the opportunity to go ahead and place with that relative up front, work with the court, get the relative approved as a caregiver, and then go on down the road until mama and daddy either get their act together and do what they need to do, or until we find another permanency option.
So the difference, just for clarity, the difference between that situation and this one is that the child would not be in foster
Not
care
foster
system.
parent until the court declares him or her to be correct.
All right, thank you.
Thank you, Representative Thomas. Vice Chair.
Thank you, Madam Chair. I just want to clarify and make sure I'm understanding correctly. You mentioned lines 102 through 113 talk about the walk through the house, the background check. I'm all for that. I will readily admit I'm not an attorney, and I still struggle with some of this language.
Yes, sir.
On line 114, you mentioned that the assessment will be completed no later than 72 hours after the time such order is entered. Does that mean that these things are happening after a child has been...
It may well be, yes, sir. So the key is we already have this practice in a lot of places. So what we try to do, whenever we can, if we have a willing relative, a willing person who already has a relationship with the child to take the child in, we want to make that happen rather than putting the child in formal state custody. So if we're able to go ahead and say we believe this person is going to be okay, but we want to go ahead and place the child there and get the process started immediately, because it is, I believe, worth it for the child to have as little disruption as possible. Is that right, Mr. Hempel?
Thank you.
Thank you.
Thank you, Madam Chair.
Thank you, Vice Chair. Any other questions from the committee? Seeing none, what is the will of the committee? Okay, move to pass from Representative Oliver. Is there a second? Second from Representative Sharper. Okay, I believe there is an amendment that the chair will entertain. We are on lines 110, I believe.
It'll be following line 113, Madam Chair.
Okay.
So there would be, on the end of line 113, strike the period at a semicolon, and put the word and then a subsection 5. If the Division of Family Services is conducting the assessment, a check of the child abuse registry, a search of the child abuse registry, excuse me. And you would also, of course, strike the word and at the end of line 110, since you've moved that to the end of line 113.
Okay, all right. So, members of the committee, do you have any questions? So basically on line 113, there will be a semicolon, and then a number 5, and then if DFACS is conducting the assessment, a search of the child abuse registry. So, is there a move for the amendment? There is a move from Administrative Floor Leader Lott. Second. So there's a move and a second for the amendment. All those in favor, please signify by saying aye. Any opposed? Okay. Movement is adopted. So now we are on the original question of passage of the bill. There was a move and a second for due pass as amended by the committee of LC 480094S. There was a move and a second. All those in favor, please signify by saying aye. Any opposed? Thank you. It moves on to rules. Thank you. We are adjourned.